In 2008, the United States Supreme Court issued a decision that many Americans believed permanently settled the meaning of the Second Amendment. But buried inside that ruling was a sentence that changed the modern weapons debate in a way few people noticed at the time. The court made clear that the Constitution does not protect dangerous and unusual weapons. That phrase, just 3 words, has become one of the most important battlegrounds in American constitutional law. Here's the surprising part. The Constitution never mentions firearms. It never says guns. It never says self-defense. It speaks instead of arms. And what counts as arms in a world of semi-automatic rifles, high-capacity magazines, and emerging weapon technologies is one of the most complex constitutional questions of our time. So here's the question I want you to think about as we begin. When the Constitution protects the right to keep and bear arms, do you believe that protection extends to weapons that did not exist when the founders wrote it? Let me know your answer in the comments. To understand what the Constitution really says about modern weapons, we have to start not in 2024, not in 2008, but in 1791. The Second Amendment reads, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." That is the entire text, 27 words, no definitions, no examples, no list of protected weapons, just a principle. For much of American history, the Supreme Court said very little about what that principle meant. In 1939, in United States v. Miller, the court addressed a federal law regulating short-barreled shotguns. The defendants argued that the law violated the Second Amendment. The Supreme Court upheld the regulation, reasoning that there was no evidence that a short-barreled shotgun had some reasonable relationship to the preservation or efficiency of a well-regulated militia. That decision is often misunderstood. Miller did not say the Second Amendment protects only militia service. It focused on whether the weapon at issue was of the kind typically used by militia forces. And importantly, the court did not conduct a full historical analysis. The case was decided without full briefing from both sides. For decades after Miller, federal courts generally interpreted the Second Amendment as tied closely to militia service. That changed dramatically in 2008 with District of Columbia versus Heller. In Heller, the Supreme Court held for the first time that the Second Amendment protects an individual right to possess a firearm unconnected to militia service, primarily for lawful purposes such as self-defense within the home. The case involved a handgun ban in Washington, D.C., and a requirement that lawful firearms in the home be kept inoperable. Justice Antonin Scalia, writing for the majority, undertook an extensive textual and historical analysis. He concluded that the right of the people refers to an individual right, that keep and bear arms includes possessing and carrying weapons, and that arms refers to weapons in common use for lawful purposes. But Heller also made something else clear. The right is not unlimited. The court explicitly stated that nothing in its opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, laws forbidding firearms in sensitive places such as schools and government buildings, or laws imposing conditions on commercial sales. And then came that key phrase, "The Second Amendment does not protect dangerous and unusual weapons." Now, pause there. What makes a weapon dangerous? What makes it unusual? And who decides? Heller introduced another critical concept. Weapons in common use for lawful purposes are protected. That phrase would become central in later litigation over modern firearms like AR-15 style rifles. 2 years after Heller, in McDonald v. City of Chicago, the court held that the Second Amendment applies not just to the federal government, but also to the states through the 14th Amendment. That meant state and local gun laws would now be evaluated under constitutional scrutiny. Then in 2022, the court decided New York State Rifle and Pistol Association versus Bruen. This case reshaped Second Amendment analysis yet again. The court rejected the means-end scrutiny framework many lower courts had used and instead announced a historical tradition test. Under Bruen, when the Second Amendment's plain text covers an individual's conduct, the government must justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. That standard has profound implications for modern weapons. Here's the challenge. The founders did not have AR-15s. They did not have semi-automatic pistols. They did not have detachable magazines capable of holding dozens of rounds. They also did not have stun guns, which became the subject of a Supreme Court case in 2016, Cayetano versus Massachusetts. In Cayetano, the court vacated a Massachusetts decision that had upheld a stun gun ban. The Massachusetts court had reasoned that stun guns were not protected because they were not in common use at the time of the Second Amendment's enactment. The Supreme Court rejected that logic, emphasizing that the Second Amendment extends to arms not in existence at the founding. That is a critical point. Constitutional protection is not frozen in 1791 technology. The First Amendment protects speech on the Internet. The Fourth Amendment applies to digital data. And the Second Amendment, according to the court, applies to modern instruments that qualify as arms. But that does not end the inquiry. The real battleground is whether certain modern weapons are protected because they are in common lawful use, or whether they may be regulated because they are dangerous and unusual. Consider so-called assault weapon bans. These laws typically target semi-automatic rifles with certain features. Supporters argue that these weapons are especially lethal and disproportionately used in mass shootings. Opponents argue that AR-15 style rifles are among the most commonly owned firearms in the United States, and therefore cannot be considered unusual. Under Heller's framework, if a weapon is in common use for lawful purposes, it receives constitutional protection. But Bruen complicates the analysis by requiring courts to look to historical analogs. And this is where constitutional interpretation becomes complex. There were historical regulations on certain types of weapons. For example, in the 19th century, some states regulated Bowie knives and certain concealable weapons. Courts sometimes upheld restrictions on weapons viewed as particularly dangerous to public safety. But are those regulations sufficiently analogous to modern bans on semi-automatic rifles? That is the question federal courts are currently wrestling with. Different federal appellate courts have reached different conclusions. Some have upheld assault weapon bans, reasoning that these firearms are comparable to military-style weapons and may fall outside the core self-defense right recognized in Heller. Others have signaled skepticism, particularly after Bruen, about bans on firearms that millions of Americans lawfully own. If you're following these developments, here's something important to understand. Constitutional law often evolves case by case. The Supreme Court rarely answers every question at once. Instead, it sets principles and allows lower courts to apply them. Now let's address a common myth. Some argue that because the Second Amendment refers to a well-regulated militia, only organized military-style weapons are protected. But Heller rejected the argument that the right belongs only to active militia members. At the same time, the court noted that the Second Amendment does not guarantee a right to possess weapons typically used by the military, such as M16 rifles. That statement has fueled arguments that fully automatic weapons, machine guns, can be prohibited. Federal law has heavily regulated machine guns since the National Firearms Act of 1934 and effectively banned civilian possession of newly manufactured machine guns since 1986. Under the Firearm Owners Protection Act, those laws have consistently been upheld. Why? Because automatic weapons are not in common lawful civilian use. They are tightly regulated and comparatively rare among lawful gun owners. So, now consider this real-world scenario. Imagine a law-abiding citizen who owns a semi-automatic rifle for home defense, target shooting, and lawful recreation. If a state bans that category of firearm, the constitutional question becomes whether that weapon falls within the Second Amendment's protection, as commonly used for lawful purposes, and whether the ban is consistent with historical firearm regulations. That analysis does not turn on political rhetoric. It turns on historical evidence, legal definitions, and Supreme Court precedent. Another common misconception is that the Second Amendment either permits all regulation or forbids nearly all regulation. Neither is accurate. Even in Heller, the court emphasized that the right is subject to long-standing regulatory measures. Constitutional rights often operate this way. The First Amendment protects speech, but not libel or incitement. The Fourth Amendment protects against unreasonable searches, but not all searches. The Second Amendment operates within a similar framework. Protection of a core right, alongside room for regulation. Here's another question to consider, and I genuinely like your perspective in the comments. Should constitutional interpretation prioritize historical practices from the 18th and 19th centuries, or should courts consider modern realities and technological change more directly? That debate is at the heart of Bruen's historical tradition test. Critics argue that it ties modern policymaking to incomplete historical records. Supporters argue that it prevents courts from substituting contemporary policy preferences for constitutional text. Now, let's talk about emerging technologies. What about weapons that are not traditional firearms? In Caetano, the court made clear that stun guns qualify as arms. Lower courts have also grappled with issues involving ghost guns, firearms assembled from parts without serial numbers, and stabilizing braces that modify pistols. Each of these disputes forces courts to return to the same foundational questions. Is the item an arm? Is it commonly used for lawful purposes? Is there a historical analog for regulating it? And here's something crucial. Courts are not policymakers. Their role is not to decide whether a law is wise. Their role is to decide whether it is constitutional. That distinction matters. For ordinary Americans, the practical implications are significant. If you own firearms, changes in constitutional interpretation can affect what you may legally possess. If you support stricter regulations, court decisions may limit how far lawmakers can go. In either case, understanding the constitutional framework is essential. Let's be clear about one more point. Nothing in constitutional analysis authorizes individuals to ignore existing law. Until a court invalidates a statute, it remains enforceable. If you have specific legal concerns about firearm ownership or compliance, consult a qualified attorney licensed in your jurisdiction. Constitutional doctrine is complex, and individual circumstances matter. As this legal landscape continues to evolve, several cases are moving through federal courts that may return the issue of modern weapon bans to the Supreme Court. When that happens, the justices will likely revisit the tension between common use, dangerous and unusual, and historical tradition. Before we close, let's step back and identify three essential takeaways. First, the Constitution protects an individual right to keep and bear arms, but that right is not unlimited. The Supreme Court has made that clear. Second, modern weapons are not automatically excluded from constitutional protection simply because they did not exist in 1791. The court has explicitly rejected that narrow view. However, protection depends heavily on whether a weapon is in common lawful use and whether regulation aligns with a historical tradition. Third, constitutional interpretation, not political preference, ultimately governs what laws survive. That interpretation evolves through real cases, real disputes, and careful judicial reasoning. Understanding what the Constitution really says about modern weapons requires moving beyond slogans and into doctrine. It requires reading the text, studying the history, and examining the precedent. Because at the end of the day, constitutional rights belong to all Americans. And whether you view modern weapons primarily through the lens of liberty or public safety, the meaning of those 27 words written in 1791 continues to shape law, policy, and daily life in the United States. The debate is not going away. The courts will continue to refine the boundaries, and the responsibility of citizenship includes understanding the constitutional framework that governs those decisions. If you've stayed with me this far, consider this final reflection. Constitutional interpretation is not just about weapons. It's about how we adapt enduring principles to a changing world. That question extends far beyond the Second Amendment, and it's one worth thinking about carefully.